All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Very much. Court officer, please put the case on the record for the day.
Thank you. Good morning, Your Honors. Situation in Darfur, Sudan, in the case of the prosecutor versus Omar Hassan Ahmad al-Bashir. Case reference ICC 0205-0109. For the record, Your Honors, we are in open session.
Thank you very much. Are there any changes in appearance?
Good morning, Your Honors. Charles Jallo with the African Union Commission, Office of the Legal Counsel, in my capacity as external counsel for the African Union Commission. Thank you.
Thank you very much, Mr. Jallo, for joining us. And now we will continue where we left off yesterday. We were taking submissions from friends of the court, the academic friends of the court, and let's now go to Mr. O'Keefe. Before you proceed, just to indicate that we will sit until 10 for 1 hour, and then we'll take a break and come back. Please.
Mr. President, Your Honours, I will be speaking on the issues in relation to immunity raised by the questions in Group A, rather than on the questions of treaty interpretation. I will start with 2 points of information or clarification before moving to the heart of the matter. First, strictly speaking, immunity imports an obligation under international law to ensure, in the present context, only that a person is not subjected to judicial proceedings, insofar as this may be necessary under the state party's national law, for his or her surrender to the court. It is a person's inviolability, where international law provides for it, not immunity stricto sensu, which imports an obligation to ensure that the person is not subjected to arrest. Now, it is generally accepted, including by the pre-trial chamber in the present case, that the reference in Article 98(1) of the Rome Statute to immunity encompasses also inviolability, since surrender presupposes arrest, and since Article 89(1), the ICC's power under which Article 98(1) qualifies, speaks of a request for arrest and surrender. It is nonetheless important to keep in mind that immunity from judicial proceedings, including proceedings for the surrender of a person to the ICC, and inviolability from arrest, constitute distinct international legal concepts and distinct international legal obligations. Secondly, when speaking of the immunity, secondly, and in relation to question G posed under Group A, in dealing with the immunity and inviolability ratione personae of a head of state, we are not dealing with sovereign immunity, as question J and counsel for the prosecutor both suggest. The immunity ratione materiae of all serving and former state officials in respect of acts performed by them in their official capacity is a manifestation of sovereign immunity, which is itself a corollary of the sovereign equality of states. The broader immunity and inviolability ratione personae of a narrow circle of high-ranking, serving state officials and of diplomatic agents and certain other envoys is a different creature entirely, even if it overlaps to an extent with immunity ratione materiae. While the immunity of a serving head of state originated in sovereign immunity, or more precisely, while the mutual immunity of sovereigns, that is, sovereign immunity, gave rise to the immunity of all serving heads of state from foreign criminal jurisdiction, the latter, immunity ratione personae and inviolability ratione personae of the serving head of state, is now more plenary than sovereign immunity, and, importantly, is today rationalized on different grounds. Whereas immunity ratione materiae is founded on the principle of respect for the sovereign equality of states, the rationale, as explained by the International Court of Justice at paragraph 53 of the arrest warrant case, for the immunity and inviolability ratione personae of those who benefit from them, among them serving heads of state, is purely pragmatic, namely, and I quote, to ensure the effective performance of their functions on behalf of their respective states. Turning to the critical issues, it is essential to emphasize, contrary to what counsel for the prosecutor and some of my fellow amici curiae have suggested, that insofar as judicial proceedings may be necessary under a requested state's law for the surrender of a person to the ICC, such proceedings constitute criminal proceedings, and as such constitute an exercise by the requested state of its criminal jurisdiction, specifically its criminal adjudicative jurisdiction over the person. Indeed, they constitute as much an exercise of its own criminal jurisdiction by the requested state as would the person's prosecution or proceedings for the person's extradition to another state. They represent, in the words of the International Court of Justice in Certain Questions of Mutual Assistance in Criminal Matters, at paragraph 170, the requested state's, quote, subjection of the person to a constraining act of authority. As such, where the person is an official of another state, surrender proceedings engage the requested state's international legal obligation to accord that other state's official immunity from its criminal jurisdiction, in the same way as would the prosecution or proceedings for the extradition of the official. To say that in surrendering the official to the ICC, the requested state is acting as the ICC's agent or jurisdictional proxy is, with respect, legally meaningless. It is also, I would point out, an inaccurate metaphor, since it is the state's parties which have conferred jurisdiction on the court, not the other way round. What engages immunity and inviolability is the subjection of the official to the power of a foreign state's own criminal courts and own police. The source or purpose of any such request for subjection is immaterial. This is the premise of Article 98.1 of the Rome Statute, which would be redundant, where proceedings before the courts of a requested state for the surrender of another state's official to the ICC, not to engage the question of the official's immunity. The same goes, mutatis mutandis, for a state's arrest of another state's official at the request of the ICC, and that official's inviolability. Now, as for the argument of counsel for the prosecutor, that the fact that a requested state party is barred by Article 59.4 of the Rome Statute from inquiring into the legality of the issue of the warrant is unique to surrender to the ICC. On the contrary, I would draw the attention of the court to the European arrest warrant, under which the executing judicial authority of a member state may not inquire into the legality of the issue by the issuing member state of the warrant. That is the heart of the European arrest warrant and a feature of the system which has proved controversial in some member states. I would also draw the Court's attention to Article 20 of the Council Framework Decision on the European arrest warrant, under which such jurisdictional immunities as may apply in the executing member state continue to apply. In other words, just as with the request from the ICC for arrest and surrender, the executing member state of a European arrest warrant is not a mere agent or jurisdictional proxy of the issuing member state. Returning to the ICC, since it is the requested state's subjection of another state's official to judicial proceedings, where these are required under its law for surrender to the ICC, and to arrest, which engage immunity and inviolability under international law, and which in doing so engage Article 98(1) of the Rome Statute, it is irrelevant that, in accordance with Article 27(2) of the statute, immunities pose no bar to the exercise by the court of its own jurisdiction. Now, that on a correct interpretation of Article 27(2), according to the rules of treaty interpretation, it pertains only to the exercise by the court of its own jurisdiction, is a point I will address in detail in my oral observations on the questions in Group C, where the issue is raised by question C in Group C. I'm only speaking here of the more structural or logical question. The unavailability of immunity by the ICC itself has no bearing on the availability of immunity as a bar to the exercise by the requested state's court of its jurisdiction in the form of surrender proceedings, let alone on the distinct availability of inviolability as a bar to the requested state's arrest of the official. Now, this point was highlighted by the Supreme Court of South Africa in Minister of Justice and Constitutional Development, quoted to us yesterday, and Salk at paragraphs 69 and 77. The same goes, and this is important, for the unavailability of immunity as a bar to the exercise by other past and present international criminal courts of their respective jurisdictions as provided for in their respective statutes. The fact, for example, that immunities were no bar to the exercise by the Nuremberg Tribunal or by the International Criminal Tribunal for the former Yugoslavia or by the Special Court for Sierra Leone of their own jurisdiction when the accused was before them is, with respect, beside the point. Now, since proceedings before the courts of the requested state for the surrender of another state's official to the ICC constitute as much an exercise by the requested state of its own criminal jurisdiction over the official as would its prosecution of the official or subjection of him or her to extradition proceedings, the question in the present case is ultimately not whether one can identify a discrete rule of customary international law positively obliging the requested state to accord the head of another state immunity from proceedings for his or her surrender to an international criminal court in respect of international crimes, as question L and counsel for the prosecutor suggest. The question rather is whether the established customary obligation on the requested state to accord the head of another state immunity from its criminal jurisdiction is exceptionally inapplicable in such circumstances, or in the more specific circumstances of that head of state surrender to the ICC on charges alleging responsibility for international crimes, among them genocide. The same goes, mutatis mutandis, for a head of state's customary inviolability from arrest by a foreign state. In other words, it falls to the prosecutor to establish positively, according to the rigorous tests laid down by the International Court of Justice and proudly quoted by counsel for the prosecutor himself, that such a customary exception exists. So does such a customary exception exist? Moving quickly over the first possible basis, the international character of the alleged crimes, and leaving aside both the crime of genocide and the possibility of a specific exception in relation to surrender to an international criminal court, I think it seems agreed on all sides that no customary exception in respect of allegations of international crimes currently exists to a head of state's customary immunity ratione personae from criminal jurisdiction and inviolability from foreign arrest. This is what the pretrial chamber says. I beg your pardon?
You will, of course, speak to the genocide.
Yes, I'm coming right now to genocide.
Thank you.
As for the crime of genocide, and in answer to question P, Article 4 of the Genocide Convention does nothing to alter the availability as a bar to foreign criminal proceedings of the customary immunity ratione personae of a head of state. Now, on this point, I endorse what has been said by counsel for the African Union. Article 4 of the Genocide Convention, which echoes Article 7 of the Nuremberg Charter, is directed not towards the question of procedural immunity, but to the substantive plea in defence that was ultimately raised and rejected at Nuremberg, that individuals are juridically incapable of bearing criminal responsibility in the first place under international law for acts performed in their capacity as state officials, the so-called substantive act of state defence, as ruled out in proceedings before the ICC by Article 27.1, as distinct from Article 27.2 of the Rome Statute. Now, this is not surprising. It is not surprising that Article 4 of the Genocide Convention does not relate to the procedural immunity under international law of officials of other states, since the Genocide Convention does not provide for extraterritorial forms of jurisdiction, and is really only in the context of universal jurisdiction, passive personality jurisdiction, and other extraterritorial bases of prescriptive jurisdiction that one would expect the immunity in relation to the crime of genocide of the head of state of another state to come before one's courts.
Can you then tell me what the point is with the Genocide Convention that says in Article 1 that, I hate to call it the Genocide Convention, I prefer to call it the Anti-Genocide Convention, but you know what I mean.
Sure.
It says in Article 1 that states parties have an undertaking to prevent and punish
Sure.
genocide.
Sure.
If what it boils down to is that states have that undertaking, but they'll exempt people
Sure.
from it.
With respect, Mr. President, this is the point I'm making. It doesn't envisage that they will...
Council has 4 minutes left.
Sure, it doesn't envisage that they will spare people, that they will exempt people. It really only envisages the assertion of jurisdiction over genocide committed on their own territory, the expectation being that it will be committed by their own people on their own territory. And when we talk about punish, we talk about responsibility. We're not really talking about the question of procedural immunity. It was also against the backdrop of the Nuremberg Charter that this was adopted. And at Nuremberg, the Allies saw themselves as exercising, and they said this in the judgment, the criminal jurisdiction of Germany.
But
Therefore,
Article 6, isn't it, of the convention says that a state in whose territory the offence occurred, or
would,
an
yes,
international
or an international court, exactly. I'm talking
will do that.
about the exercise of jurisdiction over another state's official, which is not ruled out under the convention,
No,
but
what
is
I
not.
mean is, if you hold on for a minute, with that kind of dual avenue of trial and prosecution, national jurisdiction where the offense occurred, and an international tribunal, are we still to sustain the proposition that the purpose or the object of the obligation to punish, prevent and punish, is only limited to the territory where the crime occurred?
Under the convention, yes, but that does not rule out, as the International Court of Justice has itself said, the customary application of any such extraterritorial forms of jurisdiction. Equally, I would point out that the obligation to punish can include just as much an obligation to waive the immunity of one's own official in another state. So punishment doesn't necessarily mean exercising jurisdiction contrary to immunity over another state's official. It could just as much mean that the state whose official it is obliged to waive. So the two aren't necessarily in clash, if you see what I mean. And given that it doesn't provide for universal jurisdiction, it's a bit of a stretch to suggest that it was thinking of it. If I may, thank you. When it comes to jus cogens, I would simply add 2 points to the argument of counsel for Jordan and the African Union. The first, there really is little scope for difference between reasonable minds on the matter, as counsel for the prosecutor said. In jurisdictional immunities of the state, which referred back to arrest warrant and to criminal jurisdiction saying jus cogens is irrelevant, the court decided by 13 votes to 2. Now in Australia we call that a shellacking, an annihilation. Okay? The point is dead and buried. Secondly, while I won't address it here for lack of time, I would say that Barcelona traction and the concept of obligations erga omnes is separate from the concept of jus cogens and not relevant to present proceedings. If you're happy with that, I'll take that in questions, but move on. Finally, I would simply say that there is no customary exception in relation specifically to to surrender to an international criminal court. There is simply insufficient state practice and opinio juris positively to establish an exception. No head of a serving state has ever been surrendered, first of all, to an international criminal court. Okay? So Mr. Milosevic was surrendered by his own state. Mr. Taylor was not the head of state at the time, and his own state actually requested the surrender. As for the ICTY and the ICTR, I'll deal with that in Part B in the powers of the Security Council. I will simply say in relation to my friend Professor Kress's observation that Yugoslavia was not a member of the United Nations at the time, I think, given that for 10 years or more Yugoslavia strenuously asserted its membership of the UN, and that the International Court of Justice had accepted this in early stages of the genocide case, I think it is fanciful in the extreme to imagine that Judge Hunt, or the member states that seem to go along with it, was utterly confident that Yugoslavia was not a member of the United Nations when he requested member states to arrest him. It was such a complicated question that even the genius of international lawyers in the room struggled over it, let alone Judge Hunt, who was a lovely man but was a district court in New South Wales, where I'm from, and other member states of the United Nations.
No, we wouldn't do that. Judge Hunt, we
Thank
don't
you.
want to diminish his
Yes.
stature in international law.
No, I'm only, it was a off-the-cuff remark. I'm very sorry about that. I'm simply saying it was an inordinately difficult question, and to imagine that everyone knew that Yugoslavia at the time was not a member of the United Nations is, I think, reading into the question much, much more than is, I think, probably plausible. Finally, I would simply remind the court that immunity and inviolability constitute legal obligations on the part of the forum state and correlative legal rights on the part of the official state. They are not matters of mere comity or courtesy. So there can't be a question of balancing these rights against ostensibly competing values. nor can the simple assertion of these rights constitute their abuse. Moreover, as Professor Kress does, with all due respect to Professor Kress, distinguish between heads of state responsible for international crimes, for whom immunity is supposedly not designed, and innocent heads of state, for whom it supposedly is to assume guilt. Everyone, even a head of state, is innocent until proven guilty. And when we are dealing with immunity from criminal jurisdiction, we are by definition dealing with someone who is yet to be proven guilty, or for that matter, to be acquitted. If I can be of any assistance to the court, and with sincere apologies to friends of the family, Judge Hunt, thank you very much.
Thank you very much. We now go next to Mr. Robbins.
Your Honors, my name is Daryl Robinson, and as you know, I'm here speaking for a group of professors well known in the field, Professors Cryer, de Guzman, Lafontaine, Oosterveld, Staan, and myself. Our overall position is that the pretrial chamber was correct and that the appeals chamber should affirm its decision. In a nutshell, an order under Chapter 7 to cooperate fully, in our view, includes the loss of immunities under Article 27. We see ourselves not just as advocates for one side, though, but as genuine friends of the court, and as such, we do want to acknowledge strengths of the arguments on both sides. And in the coming days, we want to suggest some possible ways for the appeals chamber to possibly recognize legitimate concerns and real difficulties in this case. Today, under Group A, I want to talk about two topics. Number one, I just want to make one point about applicable law. And then number two, I want to express my group's hesitations about the international court exception, the customary law theory. My remarks today under Ground A are actually going to sound a little bit conservative. But the reason for that is we are all supporters of the court, and we want to help the chamber reach a decision that's going to be measured and will withstand criticism. So first up, on applicable law, I just want to talk about the first question on object and purpose. We agree, of course, that the object and purpose includes preventing impunity, and yes, that's a very important consideration. We just want to register two notes of caution. The first is one that others have already pointed out, that in addition to object and purpose, we have to also look at text and context. Context includes the surrounding rules of general international law. That's in Article 31.3c of the Vienna Convention. It's the principle of systemic integration, that we want the institution to work harmoniously within a surrounding system. But the second point, which wasn't made, is I also want to emphasize that good teleological analysis requires an awareness of multiple aims and goals and values. Every legislative enactment reflects a tension negotiated between competing purposes and values. So a good interpretation has to identify the tensions so that we can make a thoughtful, responsible interpretation that would earn wide respect. I'll explain what I mean by this. I want to give you an analogy of the World Trade Organization. Often decisions of the WTO, they really emphasize that their purpose is to promote free trade. And they use an aggressive teleological approach that squeezes out provisions in their charter that were intended to protect the environment, human health, public safety. And so the WTO has been criticized for that single-minded, aggressive types of interpretation. So I just want to suggest a good teleological interpretation has to also look at the purpose of the limits and constraints in the statute. So we can advance our goals with judicial sensitivity to other community values. The Rome Statute, it's not a single-minded instrument. All throughout the Rome Statute, it accommodates other shared legitimate interests. Article 8 has a lot on military effectiveness, national proceedings, rights of the accused, national security, diplomatic relations, international peace and security. And I want to suggest that that's a strength of the statute. It's not a weakness of the statute. We want the ICC to be an enduring institution with wide support that makes a contribution as an accepted part of the system. So for that reason, I think it's important to acknowledge the tension, the concerns on the other side, preserving multilateral conversations for regional peace and security and for governance. Yesterday we had a little bit of talk about law versus policy, as if the fight against impunity is law and all other considerations are somehow inferior or inappropriate or dirty or political, which I don't think that's correct. I don't think any of these community values should be ignored. I think they're all part of a legal analysis. So that line of thinking, sensitivity to multiple aims, shapes the position that my group of scholars would suggest to you. Again, we think the pretrial chamber approach was correct and should be affirmed, but the court should be judicious and acknowledge concerns. So one, in the coming days, I want to point out that there might be some legal avenues to accommodate some legitimate concerns, particularly where there's a treaty providing immunities for a conference of an international governmental organization. There are some legal avenues that maybe that could be recognized, and if so, it would address one of the strongest concerns expressed by a lot of states parties. It's a possibility, it's up to you. And the second line for us is that we can acknowledge that there was a genuine controversy and real legal uncertainty here, and maybe look at the position of the state of Jordan with some understanding, and that maybe the solution is for the appeals chamber to just simply clarify the law for the future. So that's on the applicable law. So the rest of my time, I want to speak about a lot of the questions are about customary law and this international courts exception. And now here I'm in an awkward spot in that I historically almost always agree with my excellent friend Klaus Kress. So this is somewhat painful for me, but my group of scholars, we would unanimously urge the appeals chamber not to adopt the international court exception at this time. All of us are supporters of international justice, but we have principled concerns, principled legal concerns, at least about it at this time. Maybe let's come back to it in 30 years with more practice and more authority, but it might not be necessary for today. First of all, it's not clear that it's really raised on this appeal by Jordan and as granted by the pretrial chamber. Second, the international court's argument, it emerged in the Taylor decision of the Sierra Leone Special Court, and it has received severe criticism, even from strong supporters of the court. Arguably it does not fit very well with some basic legal principles. I'll explain what I mean by that in a moment. And third is a matter of judicial economy. We have available a classic route rooted in state consent, indirect state consent, the Security Council Avenue. So it just seems the more economical and narrow approach where you have a Security Council referral to use that. Let me elaborate a little bit more. This theory in the Taylor case, which is—
Mr. Robinson,
yeah.
do you see any solution to this question that would not be open to severe criticism?
I mean, to me, the solution would be give it a couple more decades, accumulate more. If the theory gets support in national decisions and international law commission statements, if over time it could build up a strong body of state practice and opinion juris, then I think the time would be right to try it. Is that a no? Okay. So this theory emerged in the Taylor case that by virtue of being an international court, the court doesn't have to respect immunity. I think there's problems with that, not just as a rule, but how that rule even fits within the system of international law. And let me illustrate what I mean. To take two countries, neither Canada nor the United Kingdom on their own have the power to ignore the personal immunity of another state. And so I don't think those, Canada and the UK, can create a court together and bestow upon it the power to ignore the personal immunities of another state. They cannot bestow a power that they themselves don't have. And I think that problem exists if it's 2 states or 10 or 50 or 100. They cannot bestow a power they don't have. And I think that's fundamental. And the ICC is a court of law, and a court of law has to be built on a bedrock of legal principles. Now, the argument then for the international court theory is the international court says, well, I'm not just an aggregate of states parties. Guess what? I represent the entire international community, and therefore I have special powers. I think that the targeted state would be entitled to some skepticism of that kind of claim. Nowhere in international law is there any principle or doctrine where claiming to represent the international community gives you the power to ignore rights of non-consenting states. You can look at all the textbooks you want, Shaw, Oppenheim, Brownlee. There's no other rule like that. So it just strikes me as an unknown legal technique. The basic structure of the international legal system is state consent, so it's better to try to find state consent. I think there's concern, particularly in the global south, about this type of claim that, oh, I'm acting for the international community and therefore I have special powers. The worry about it is that it gives those who have voice in the community even more power to override the rights of outlying states. And that's why I think it's better to root yourself in state consent. Either direct state consent, the state ratifies the statute, or indirect, they ratified the UN Charter, including Chapter 7 and the powers given there. But then what about this arrest warrant decision by the ICJ? We think that the Taylor decision of the Sierra Leone Special Court put inordinate weight on one sentence in the arrest warrant decision, and we think it took that sentence out of context. I don't think the ICJ was declaring a new, previously unheard of substantive rule. If they were, there would have been some support, authority development, argumentation. I think it was a passing remark. I think the ICJ was simply addressing possible concerns about impunity, and they were gesturing to avenues of recourse. And they said, look, you can get waiver, you can wait till he's out of office, or you can go to international courts. I think they were just simply observing that there are international courts that have the power to supersede immunities, but they have that power in accordance with known principles of international law. The tribunals can set aside immunities because they have Chapter 7. For the ICC, you can set aside immunities where you have a state party, or the state has accepted the courts, has unilaterally accepted the obligation to comply, or where there's a Security Council order. Another question that we were given is, well, is there enough state practice and opinio juris to show that specifically international criminal courts have to respect immunities? So it's demanding practice specific to international criminal courts. But I think that question has the wrong frame. As Mr. Talati said yesterday, I think it reverses the onus of customary law. An international criminal court is a creation of states. It's still part of the international legal system, and it's still governed by the same legal principles unless there's some recognized legal basis for it to be different. I think you can't just sidestep all the rules by saying, oh, well, those rules say state, and I'm not a state. To give an example, the prohibition on the use of force says that states may not use force. So states can't get together, create an international organization, and have it use force, and then the organization says, oh, I'm not a state, I'm an international organization. Instead, the same principles apply. International criminal courts are state creations, by default, subject to the same rules, the same system, the same principles. And we can look at their statutes to see what special powers have been bestowed upon them by consent. And if we look at the practice of international criminal courts, in setting aside personal immunities, I think in every case we'll see that there was a consent-based basis to do so. So in Nuremberg, Germany had unconditionally surrendered. So the Allies were the executive, legislative, and judicial branch. There was the consent there. Other times you have ratification of the ICC statute. You have Security Council, where all UN member states are obliged to carry it out. The Milosevic situation is a tricky one, but there's two answers to that. One, the Federal Republic of Yugoslavia was claiming and insisting that it was the successor state to Yugoslavia, so it claimed to be a UN member state. And in any case, the FRY had ratified the Dayton Accords, in which it promised to cooperate fully with the tribunals, and as we'll be submitting in later days, I think the obligation to cooperate fully includes a removal of immunities. I'm almost done, which is great. The Jus Cogens argument, I think people have already addressed this enough. The argument is, well, genocide is Jus Cogens, therefore that overrides immunities. That argument, others have addressed it. The International Court of Justice has addressed it. The European Court of Human Rights has addressed it. The problem with the argument is the Jus Cogens prohibition is on committing the crimes. And as the ICJ has explained, that's on a different plane from these issues of prosecuting immunity jurisdiction. As the International Court of Justice explained in Germany versus Italy, just because Germany committed Jus Cogens crimes doesn't mean that immunities don't apply. And then we also have the Al-Adsani decision of the European Court of Human Rights. The Jones case, the UK House of Lords, International Law Commission, a report on Jus Cogens. It's a pretty strong body out there. Yesterday we talked about Nuremberg Principle 3, which was interesting and important too. I think though that Nuremberg Principle 3, I think it's customary law, but it talks about responsibility. Just because you have official capacity doesn't mean you're not responsible. It means that you're still responsible for your crimes. So I think that is about functional immunity. It's about being responsible. Personal immunity, as the ICJ explained in the arrest warrant case, is different. It has a different rationale. It's not about the individual's responsibility. It's about a procedural shield. And there's authorities for that Nuremberg Principle 3 is about functional immunity. One authority would be the Alabeek Treatise on International Law. It's cited in our brief. And another is the ILC report on Jus Cogens. So there's a couple authorities in that vein. I think I'll just finish ahead of time. For further arguments on this, I would refer you to the Cryer et al. The Treatise on International Criminal Law, Chapter 21. On the customary law, I mean, the Chamber doesn't have to close the door on it forever. You could just leave it open, which would be fine. But there's no need to decide it today. We have a Security Council order to a UN member state. And yes, there's interpretive disputes, which we'll be talking about in the coming days, but that seems to me the much more secure, narrow ground. So in the name of judicial economy, I would suggest that's how to resolve this. Thank you, unless you have any questions.
I actually do.
I thought you might.
About the distinction, procedural versus substantive.
Yeah.
There was that case from the Supreme Court of Canada. I think it's called...
Bazari, maybe?
No. Tollefson and Jensen. Tollefson and Jensen, where Mr. Justice Laforet basically decried that kind of distinction, procedural versus substantive, saying the Canadian judges are moving towards a trend of disregarding it. He put it in rather tough terms. Before that, there was a case out of the Australian High Court, I think it's Maxwell and Murphy, where the Chief Justice, Dixon, I think he was then, also was very critical of that kind of distinction. And then we see a repeat of that criticism by Judge Elton Akesone, who I didn't need to mention, very authoritative jurist in his own right from Jordan, who also, in their arrest warrant case, said that it is a very artificial distinction that seeks to circumvent an embarrassing question of whether immunity would translate to impunity. Now, you see where they're going with this. And as I asked the question yesterday, we are in a criminal court where somebody today has said there is a presumption of innocence. It is about a process, and Judge Karoma, in the arrest warrant case, distilled that distinction while supporting it. It's about freedom from legal liability. He said that's not what immunity is about. Immunity is rather about the exemption from legal process. I'm using precise terminology he used, exemption from legal process. And the question becomes this: at what point, when do you get to legal liability if you are exempt from the legal process in a criminal case? Can you tell me, please?
Yeah, excellent. First of all, I will look at those cases with interest. I absolutely sympathize with your point, and you made. I thought you made a very good point yesterday about if there's continually procedural barriers, you never get to the substantive responsibility, and I thought that was a very strong point. The answer, I suppose, however,
it wasn't about a point. I wanted clarification. I want you to help me answer because these are things we must deal with.
Sure. I think the answer is there are always this problem disturbs jurists in all immunity cases, not just criminal but domestic. In immunity cases around the world, you'll often be confronted with something awful. A drunk driver has killed someone got tortured. Immunity cases are always frustrating. Immunity does admittedly frustrate the ability to apply justice. The problem is if we do what you suggest and sort of erase procedure versus substance, you would wind up erasing immunity eventually, which is would be quite a big step. Do you see what I mean? Now, there is a problem still remaining. What about these heads of states of non-state parties, right? There's this gap, and I agree. But my answer to that is we should keep doing our work, keep trying to do credible work, promote ICC ratification, and eventually get universal ratification as the solution. I realize that's a long-term way, but that's the legal way.
I will need further help from you if you can. Again, I return to Judge Akasone, and also this time the joint separate opinion of Judges Higgins, Coimans, and Wagenthal, who sort of, were not too enthusiastic about those exceptions or those saving or recovery arguments made in paragraph 61 of the arrest warrant case. And I think it was Judge Alcasone that said, look, these kinds of crimes are usually, according to him, if I remember, or the joint judges, maybe some things you say government officials commit. And in many countries, with the exception of France and Kenya, for example, who have made an exception for their own heads of state when being prosecuted under the Rome Statute, many countries have this exception that the heads of state will not be prosecuted in their countries. And when you have a head of state for life, or a monarchical head of state who wields executive power, by definition stay there for life. At what point do you get to the legal liability if you exempt them at home and then exempt them overseas as well?
Again, my answer would be keep pursuing universal ratification of the ICC. My other thought, again, I agree with you about the difficulty of this big puzzle, but I would say let's.
So until then, until we get universal ratification.
Until we get to universal ratification, I would say let's work on the case before us, and the case before us is a state subject. It's a UN member state that's been subjected to an order to cooperate fully. So I think we can resolve the case before us in a without having to figure out this much more difficult question of an international court's exception. How about, yeah? Thank you.
Thank you very much. I think we now can take the responses. First from the prosecutor, 5 minutes.
Thank you, Your Honour. Judges. I wanted to make 1 or 2 brief points in the 5 minutes allotted, but of course, as I heard the very thorough presentations this morning by Professor O'Keefe and Professor Robinson, there are additional things that I would like to respond to, but perhaps I won't use the 5 minutes here, and if you allow the courtesy, perhaps in the Q&A session when we have quite a lot of time, we can come back to some of those important points that were raised. I just wanted to make some very brief observations. Of course, we're very happy that we have the benefit of the presence of the AU and Arab League and Jordan itself, of course, and other scholars who can guide us on the question of customary international law in this issue. I just wanted to pick up on the point that Professor Clary made yesterday, that there are, of course, several cases that support Jordan's proposition. We don't doubt that there are such cases, and indeed we also refer to them. I think what we merely observe is that there are also ample examples that point in the opposite direction. And we clearly cannot be satisfied in resting on only on one set of cases and not looking at the others. So we ask, for example, in relation to the existence of such cases, and the suggestion of an apparent positive practice by states confirming Jordan's position, how do we then respond to the statement made as recently as July of this year by a group of some 35 states, which we cited at paragraph 22 of our filing 377, that these 35 states condemned the failure of Djibouti and Uganda to abide by their obligations under international law. Those were the terms that they expressed it. Or how should we consider the emphatic position of African states such as Botswana and Malawi, among others, and this was at reference A19 in our submissions yesterday, that have said that they would honor their duties to arrest and surrender Mr. Bashir, or indeed the recent Kenyan High Court ruling that affirmed the same. How should we characterize the implementing legislations of states such as Australia, Canada, New Zealand, Germany, South Africa, Croatia, Trinidad and Tobago, Samoa, Estonia, etc.? Are all such states to be considered persistent objectors? Or have such states acted contrary to their international obligations and the requirements of customary law? We say a more reasonable approach is to suggest that state practice and opinio juris on this matter, as evidenced by this divergent practice and opinio juris, is indeed unsettled. Now, we also heard yesterday some insight about the ILC's considerations of draft Article 7, in particular this subparagraph 3 that we referred to yesterday. And again, we're not saying that you've come to a conclusion on it. You mentioned that 5 members wanted it out, 1 member wanted it in. I think we can only be guided by the records of the ILC's own debates. So we merely pointed to the fact that indeed some members wanted to continue the discussion. But also we look at the most recent ILC report just
Mr. Rustin, you are addressing us, not the
Yes, sorry. The most recent ILC report, I'm responding, so I apologize. So the most recent ILC report is reference A/73/10. And I just want to cite the paragraphs, your honors can examine them further. Paragraphs 277, 280, and 327, we find that consideration of this issue about a possible exemption from customary international law and the circumstances that were described yesterday concerning international courts and tribunals, their surrender process, that this remains ongoing. And if we look at the reported views of those members that did not want to consider this issue further, we see, and I quote, This is paragraph 327. Quote, while some members supported studying what effect the obligation to cooperate with the International Criminal Court might have on the immunity of state officials, others opposed such a consideration, viewing it as incompatible with the agreed scope and draft Article 1, according to which the draft articles were without prejudice to the immunity from criminal jurisdiction enjoyed under special rules of international law. In other words, that this issue did not fit within the scope of the Customary International Law study, the study in relation to the Customary International Law affecting state officials from foreign criminal jurisdiction. Now, if those ILC members felt so clearly that existing interstate custom in fact also encompassed the ICC surrender process, which is also the proposition put forward by Professor O'Keefe, we would have expected that they would have expressly affirmed in their study that the ICC surrender process should also be captured within the scope of the present study and drafted, in fact, a rule attaching to this important conclusion. Instead, we find the opposite. We find that either ILC members believe that it falls outside the scope of their mandate, or they have considered, albeit maybe a small minority, a draft rule that would expressly exclude it from the scope of existing immunities. Now, in any event, I don't think we need to debate here the ILC's own internal processes. Colleagues here are much better placed to do that, because we believe that the underlying state practice, as we come back to again, and opinio juris, is, as we stated, so unsettled.
Your time is up.
Okay, so I'll address the remaining points I wanted to make later on, but that's fine for now. Thank you.
Thank you very much. We still have some time at the end.
Thank you.
I think on Friday for the rest to be said. Now we have the response from Jordan. Yes.
Thank you, Mr. President. My name is Sean Murphy, and I'm appearing on behalf of the Hashemite Kingdom of Jordan. It's a great pleasure to appear before you. In the 5 minutes that I have, I would just like to touch on a few of the many points that were raised over the course of the past day, starting with our reiteration of the point made by Ambassador Hamud in his opening statement, which is that this is an appellate proceeding. There is a pretrial chamber decision below that reached very specific findings on fact and law. The government
are you arguing ultra petita now?
I'm arguing, I hope, Mr. President, that in thinking through the issues that are currently being discussed, in our view, it's important to keep a focus on the decision below and what was decided and what was not decided, and I hope a focus on the grounds of appeal that we've brought before you. Nothing beyond that.
But you know about so many authorities that say the court can look at what it needs to look at to arrive at its decision.
And in the event that the court wishes to speak about aspects of law or fact that are beyond the scope of our appeal, our submission would be you might end up upholding all three grounds of our appeal, and in the course of doing that, speak to aspects of law that you wish to speak to.
I'm sure you'll like that very much.
For example, Mr. President, the issue of head of state immunity is not on appeal before you. The pretrial chamber, as we indicated, was quite clear in finding that President al-Bashir has head of state immunity. And we accept that conclusion. We did not appeal that conclusion. The prosecution did not appeal that conclusion. And although the prosecution sought to expand the scope of what was being appealed, the pretrial chamber refused to allow it to do so. Consequently, while we've heard many issues here discussed about head of state immunity, we didn't brief that in our appeals brief. And we do feel that we're being placed in a difficult position at a relatively late stage of the process in having to address that issue. I don't have time to do it right now. We are willing to do it if there's continued interest on the part of the court with respect to that issue in the question-answer period. We would be happy to return to it.
I don't want to detain you by prolonging this discussion between us, but if I remember, the ambassador, when he was making the opening statement, actually did say that this is very important appeal. It deals with head of state immunity. I think the transcript will show that. But go on, please.
You're absolutely correct, Mr. President, that we do understand that there are very important issues here. Our view is that they don't actually have so much to do with the case below and the grounds we're appealing on. And again, if the court wishes to go off in a particular direction, we just hope that you'll bear in mind what it is that we were trying to bring before the court, and bear in mind that in the context of the written proceedings as they unfolded. We would be happy in the Q&A period to talk about head of state immunity if that's helpful. With all due respect, I think the prosecution completely misunderstands what's happening at the International Law Commission, and we would be happy to go into that. I sympathize. It's not easy to follow what's happening sometimes at the Commission, but if I can, I'd like to move on to a second point, which is that the prosecution said that the Vienna Convention on the Law of Treaties is a central starting point for interpretation, the rules set forth in Articles 31 and 32. We completely agree with that, but we would note that the prosecution immediately blows past the starting point for that analysis, which is the ordinary meaning of the text of the treaty provisions at issue. They didn't spend any time talking about what does Article 27, paragraph 2 actually say. What does Article 98 actually say? And after looking at that ordinary meaning, thinking about the context, one is in Part 3 of the statute, which has everything to do with the way the court operates and very little to do with the court's cooperation with member states, while Article 98 is in Part 9, which has everything to do with cooperation with the states. And we think that context is quite important. They didn't talk about Article 31, paragraph 3's concept of subsequent practice of states parties and how they are interpreting Article 98 and any possible relationship with Article 27. States parties don't seem to see Article 27 as having this effect on Article 98 that the prosecution is now advancing, and no discussion of the travaux préparatoires. Did the drafters at Rome believe that Article 27 was having this powerful effect on Article 98? There's no evidence of that whatsoever. I have very little time. I'd like to pass on to a third point, this idea that Article 98 is only creating some sort of procedural obligation that the court is able to, perhaps in its discretion, apply or not apply. We just don't think that's a plausible interpretation of the article. Part 9 is replete with the concept that states are cooperating with the court in accordance with the provisions of Part 9. And it talks about, and I'm looking at Article 89, that states parties shall, in accordance with this part, comply with requests for surrender. So that by the time you get to Article 98, where it says the court may not proceed with the request in certain circumstances unless it gets a waiver, that's all part of a single package, if you will, that can't be expressed as simply a question of the court having an option to do something or not do something. And my last general point is much discussion was made here about this idea that the states being requested are agents or proxies of the court. We generally agree with much of what Professor O'Keefe said on this point. I would just reiterate that there were questions yesterday about Article 59, for example. Article 59 says that a state party, upon receiving a request from the court,
Your time is up.
Unfortunately, we have to stick to the time. Hopefully, you will also return later on.
thank you, Mr. President.
We will now rise for 30 minutes, and then we will return. There will then be questions from the bench. Maybe that would give council opportunity to clarify or finish some thoughts they had.
All rise.